Welcome to the Legal Lounge here on CRN Digital Talk Radio, CRNTalk.com, streaming live coast to coast around the world on CRNTalk.com, and soon stunning high-definition video on Facebook.com/CRNTalk, on CRN's custom-built Roku channel, Tiki Live, and of course, CRNTalk.com. I am joined, as always, by the one and only, an active attorney, U.S. Army veteran, Juris Doctorate in law, undergraduate degree in physics, and author of a book that has proven to be a guideline for the Supreme Court now and in the future. That book, America: An Illusion of Freedom, is available on Amazon, Barnes & Noble, and on iTunes. Ladies and gentlemen, Mr. Richard Nixon, and the show that gives you the news you get nowhere else. How are you, Richard?
Yes, and that is so true. It's truer by the day, Mike. Every week we come up with something that I don't hear anywhere else. Just very quickly, we have an article by Mr. Professor Erwin Chemerinsky. Oh, yeah. The title of his article is Upholding the Rule of Law, but I amend that, if you will, to Upholding the Rule of Law while ignoring the Constitution. Mm-hmm.
We're going to definitely speak to Mr. Chemerinsky's article moving forward, Richard. Just real fast, let's check in with what's going on in the Supreme Court.
Yes.
Let's talk a little bit about the oral arguments that both you and I listened to last week, Trump versus Anderson. This is the Colorado 14th Amendment, Section 3, and the justices, even the liberal justices, seemed not to take the Colorado, Mr. Anderson's argument holding much water.
That's true. And again, the 14th Amendment, Section 3 basically says that if you are a person and you want to run for office and you've taken an oath and you also engaged in an insurrection, that you cannot take office again. However, it doesn't apply to president as far as I'm concerned, because the word president is not explicitly stated. And the other avenue by the left is that he might be construed as an officer of the United States. We've been through that. We've shown, I think, at least to our satisfaction, that the president is not an officer of the United States, and therefore he is not precluded under the 14th Amendment, Section 3, from running for president again.
Correct, and it seems like the Supreme Court justices are in agreement, and I would expect at a maximum a 9-0 decision, and a minimum, I would say, a 7-2. Even Justice Ketanji Jackson Brown seemed very, very skeptical of the arguments laid forth, and Justice Clarence Thomas, he pretty much backed the attorneys into a corner regarding the purpose and the history and intent of the 14th Amendment, Section 3. So we're going to be looking forward to that decision. But we're going to talk a lot today, Richard. We have a couple things to talk about. Of course, we're going to touch upon the just completely over-the-top $365 million civil verdict against President Trump in his New York State fraud case. Actually, the figures, once you account for interest, are closer to $450 million. And then we're going to talk about immunity. We're going to talk about the January 6th case. This is known as Trump v. U.S., which President Trump and his attorneys have petitioned the Supreme Court to review after a D.C. Circuit Court ruled that President Trump does not enjoy immunity from criminal prosecutions after he left office. A lot to talk about today, Richard. We are here in the Legal Lounge.
Did you call her Kentucky Jackson?
Ketanji Jackson.
That's close. I'm going to call her Kentucky Jackson from now on.
Okay. Stick around, you guys. We'll be right back right after the break. Stay with us.
Are you nearly maxed out on your credit cards? It doesn't matter if you're using your credit cards for fun or to survive. At the end of the month, your statements come in, and you can either pay them or you can't. If you can't, late fees and interest rates get tacked on. And now you're struggling just to make the minimum payment due. Do you feel trapped? Am I talking to you? Good, because I personally researched some companies that can help you. They may be able to reduce your credit card balances by 50% and stop the late fees. If you qualify, please call our special debt hotline number right now for a complimentary free 5-minute consultation. Deal with your credit card problem now before it gets much worse and put more money back in your pocket. Trust me, I've been there too. Call right now.
800-475-7125. 800-475-7125. That's 800-475-7125.
And we are back in the Legal Lounge. Once again, thank you so much for joining us. All past and previous sessions of this high-quality broadcast are available on YouTube, also on Rumble. Find CRN Digital Talk on both those platforms, as well as a podcast at crntalk.com/podcaster. All right, Richard, the news hit yesterday. This is a case out of New York. This is a civil case having to do with the Attorney General of New York. And federal judge Arthur Engoron, he has been battling with Trump and Trump's attorneys regarding said civil case. And this has to do with allegations that President Trump, through his businesses, would inflate real estate values and personal net worths, brass taxes that he's alleged to have kind of altered his financial records in order to secure more favorable loan terms from his creditors. It should be noted, too, that those creditors, these banks, were not a party to this suit.
Correct.
This suit was solely brought by the New York Attorney General. It was not had anything to do with any sort of fraud or anything that alleged from former President Trump's business partners. However, New York, this judge ruled that Mr. Trump and his business need to pay $364 million plus 10% interest going back a couple of years. So it's around $450 million in penalties. Also, Mr. Trump and some of his children, as well as his former business partners, are not allowed to serve on any corporate boards for 3 years and not allowed to do business with any bank out of the state of New York.
Yes.
Your thoughts on this?
Well, again, a major portion of that big number of 354 million is prejudgment interest. Now, this is typical. In that state, it was only 9%. Here in California, it's 10%.
Well, hold on, only 9%?
Yeah.
I mean, Richard, I'm paying, I get like what, like a less than 1% in my savings account?
I know, and this is why people will come to me oftentimes and say, I want to cash in on this judgment. Let's satisfy the judgment. And I'll tell them they're getting 10% on that judgment right now. If you know that person is liquid, let it ride. That's the best investment you can have.
It's better than Treasury bonds.
Exactly. So my point is, don't be fooled by that, because that can be undone here. But my point is, too, that Mr. Trump, according to his position, could show that there were no victims. That is to say, that even the banks appeared and said they had not been damaged.
And they continue to do business with them, too, those banks.
They were paid off on time, and they probably each made a profit. But here's the problem. Apparently, what the prosecutor is arguing is much like they used to argue the marijuana cases or the prostitution cases. No one is being harmed by it. Therefore, why do you have a law against it? And then, the conservatives would come out in this case saying, well, society is harmed and so on and so on. I understand, though, that you could construe some of the statutes they used as not requiring any victims. It's a de facto or strict liability, if you will, that if you commit this thing and you're misstating something, you've committed the, quote, I won't call it necessarily a crime, but the tort, and therefore you're liable. Now, I'm hoping that Trump will be able to show that he did not get a fair trial and that both the judge and the prosecutors were not fair to him, and maybe get a reversal based on that.
This was brought by New York Attorney General Loretta James, who has pretty much had it in for Trump since day one.
Is that Letitia?
Loretta James.
Oh, okay.
She's pretty much been vociferous in her opposition to Trump even before this case was brought.
Absolutely.
And Judge Engoron, he had the ability to give what's known as the death penalty, which is pretty much barring, not that kind of death penalty, Richard, the death penalty barring Trump from doing business for life in New York.
Yeah.
But then in his decision, he wrote that we're not going to do that because that would present undue economic harm to all of Trump's employees.
Oh, yeah.
But now, I mean, if Trump's got to pay this amount of money and Loretta James has it in for him, he's just going to move all of his businesses out of New York,
of course,
which is going to do the same thing to the employees of the Trump organization in New York.
That's right. So I don't know how this is going to shake out, except it looks as though it's going to have to be decided by the U.S. Supreme Court, much in the way they decided the Trump versus Anderson case that we just mentioned. where cooler heads prevailed, and even the liberals got on board going for Trump. I think the situation here in this particular case is way overboard, and he did not get a fair trial, let's put it that way. And under the Constitution, due process means fair trial.
Well, also, I'd imagine there's probably an Eighth Amendment challenge here for
that could be.
For excessive fines. Apparently, according to reporting, Richard, he's got 2 paths he can move forward with for appeal. In terms of the judgment, he can bond the entire amount.
Yes,
which would be very expensive. Or he could actually continue without bond, but then allow collection to begin.
Right.
And so he could do the appeal, and then the New York State can go after his cash. And then I guess if he's exonerated on appeal, they'd have to pay that money back.
Well, there's something else he could do right now, and maybe his attorneys have already tried it, and that is make a motion for a new trial. And then what happens, you sit down with the plaintiffs, which in this case is the state, and you say, look, you either give me a better deal here, cut it in half, 50%, or I'm going for a new trial, and we're going to have to go all over this all over again. Sometimes, for instance, wipe out all that prejudgment interest. Now, remember, prejudgment interest starts the day that you claim that the defendant harmed you. So from that date forward, it runs until you finally get your judgment, which is now. That's where that huge number comes from. And as you said, it's compounded 9% per year in that state. But in California, it's 10%.
Wow.
So, yeah, that's a big chunk of change right there. And he might be able to simply resolve it by agreeing to a smaller number.
How would that play out politically for him, though? I would think that to fight this all the way.
Well, if he argues or he tells the people he's doing it so that he can be free to run for president, he might buy it. Mm-hmm. They might buy it. I don't know.
Also, a lot of his legal fees have been paid by the RNC. I doubt that the RNC would want to be on the hook for this kind of judgment.
Right.
And also, he will have to probably liquidate some properties in New York for...
Okay, that was the other thing, Mike, that we wanted to discuss, whether it's really a judgment or an order.
Yeah.
An order is something that is pretty much now, it's immediate. You are ordered to do X, Y, Z. A judgment simply says to the defendant, in this case, Trump and his family, you have been adjudged to be liable to someone for that money, and now it's going to be up to, in this case, the government, to figure out how to collect it.
Yeah.
So I see the term is often interchanged. I'm not sure which one it is now, whether it's an order or a judgment. The media doesn't seem to know the difference, and they use the same term. Maybe we can find out and let the audience know.
Yes, the research staff will get on that.
Next week is good enough.
Okay. And this was a declaratory judgment as well, not punitive damages, because punitive damages would require a jury for that.
Right.
And this was a bench trial. So stick around, you guys. We got a lot more to talk about here in the Legal Lounge. Make sure to check out Richard's fantastic book, America: An Illusion of Freedom. Is available on Amazon.com, Barnes & Noble, and on iTunes. And also you can email Richard at pres37th@aol.com. And that email address is on the screen if you're watching this, or in the description below if you're watching on YouTube. Stick around, you guys. We'll be right back.
No more mold, no more damage, no more outdated old bathroom, no more slipping and hurting, no more stress. Make your ordinary bathroom extraordinary for only $99 per month. New shower, new door, new tub, new wall, new anti-slip technology. Be stress-free. Call 800-973-5411. BCI Bath and Shower is made in America for the highest quality. Ask about our military and senior discounts. Your dream bathroom in as little as 1 day. First 50 callers save $1,500 on a never clear glass treated door. Call now for free premium color upgrades. 800-973-5411. Call BCI Bath and Shower, the leader in bathroom remodeling. Be smart, safe, and stay a step ahead of inflation with our interest-free financing options. Call 800-973-5411. Love your bathroom with free upgrades. Call 800-973-5411. 800-973-5411.
you're experiencing pain, back pain, shoulder, elbow, or hand pain, pain from a sports injury. If so, schedule a visit with Dr. Michael Sheps, the leading expert in laser therapy for pain management. Call 310-873-4422 or go to drsheps.com. Experience Epic T, the breakthrough laser therapy system that Dr. Sheps developed to make you pain-free in less time. Laser therapy is a non-invasive, safe, and effective in-office procedure that penetrates deep into your skin without damaging the tissue. It perfectly targets areas of pain to promote fast, natural healing. Relax your muscles, ease muscle spasms, joint stiffness, and arthritis pain while increasing blood circulation. For over 25 years, Dr. Sheps has helped Olympic athletes and sports enthusiasts alike get back in the game. Schedule your visit with Dr. Sheps at his Brentwood office in California. Call 310-873-4422 or visit drsheps.com. That's DRSHEPS.com. 310-873-4422.
Attention real estate investors. Do you need cash immediately? If you own one or multiple rental properties, you can use your equity to get cash out fast. The best part is we don't need tax returns or even a good credit score. At America's Loan Source, we are not a bank and we don't have bank rules. We make the decisions to loan you money, and there's no limit how much we can give you. Some clients have gotten as much as $500,000 or more within days. Use the money any way you want. If you own one rental property or 100 and COVID has left you in a cash crunch, we can help you turn your equity into fast cash. Call now for details and close in as little as 10 days and get the cash you need. 800-353-1760. 800-353-1760. 800-353-1760. That's 800-353-1760.
We are back in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com. We're going to spend the next couple segments talking about immunity. We're going to talk about, this is a case, this is Trump, this is US v. Trump. This is known colloquially as the January 6th case. This is Jack Smith's baby. This has to do whether or not Mr. Trump has engaged in several crimes, and some of these crimes include, I'm going to read some of the charges here, conspiracy to defraud the United States, conspiracy to obstruct an official proceeding, obstruction of an attempt to obstruct an official proceeding, and conspiracy against rights, whatever that means. And Mr. Trump has filed some motions saying that he enjoys presidential immunity even after he has left office, because I think we all know, and well established, most people who have listened to this show, is that a sitting president cannot be cannot be charged criminally,
correct,
and cannot be charged civilly. And that comes back to all sorts of established case law. Whether or not a president can be charged after the fact has yet to be resolved.
Correct.
And so President Trump's attorneys filed a motion to the D.C. Circuit Court, and the D.C. Circuit Court ruled in a joint opinion that he does not enjoy presidential immunity after he left. Mr. Trump has taken his right to appeal this to the Supreme Court, and the Supreme Court will hear arguments about this week.
Yes.
Okay, Richard, so let's talk about why some of the arguments, and I have this from several sources here, on why former President Trump may not be immune from criminal prosecution. Number one, constitutional limits. While a sitting president may have some immunity from prosecution due to the responsibilities and separations of power outlined in the Constitution, the immunity does not extend indefinitely. You wrote a very fascinating and very thoroughly researched article that I think deserves much respect and kudos on why actually Mr. Trump is immune from prosecution. Proceed, sir.
Yes, thank you. First of all, this case, the D.C. Circuit's ruling is the first time that a federal court of appeals has expressly held that a former president may be prosecuted for crimes he allegedly committed while he was in office. And there is an article by Erwin Chemerinsky. I have to give him kudos for this because he does do a little bit of research, telling us that under certain circumstances, a sitting president can be responsive to or must be responsive to a subpoena.
And that comes from Trump v. Vance.
That's right.
And the holding in that case by John Roberts is it goes only as far to say that a sitting president can be served with a subpoena, nothing else.
Correct. And then you have the Nixon versus Fitzgerald case, 1982, which basically said that although Nixon's presidency had ended 8 years earlier, the court found that he had absolute immunity for those acts taken while in office. Now, this was strictly for a civil action for damages and so on. And then we had number 3, 15 years later, in the Clinton case, which I think is almost dispositive of the issue if the Supreme Court tries to follow stare decisis again. And it says here that the Supreme Court, this was Mr. Clinton versus Jones.
A civil case as well.
Right. Unanimously held that a president does not have immunity for acts taken prior to assuming office. So we're dealing with what he did as governor of Arkansas.
Which is not at issue with this Trump case.
Correct. In that case, the court said that absolute immunity exists to protect the exercise of discretion while in office and does not preclude or include acts taken before becoming president. Now, this to me is the rationale for why the president should enjoy, and I think does enjoy, total immunity while he's president, because we don't want to interfere with his exercise of discretion. If he's looking over his shoulder every time he makes a decision, whether it's domestic or dealing with foreign people in other countries and so on, if he's worried that, if I do this, will I be prosecuted once I leave office? This is why the Article 1, Section 7, I'm going to read it real quick, Mike. Article 1, Section 7 says that it's the impeachment judgment clause. Article 1, Section 7 states, in pertinent part, judgment in cases of impeachment shall not extend further than to removal from office, but the party convicted, underline the word convicted, in our case it would be the president, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. 2 things I want to comment on there real quick.
Well, hold on, Richard. So hold your fire there, because we're right against the break. I want to give you the maximus amount of time to really flesh out this argument, because I think it's really important. Stick around, you guys.
Very good.
We're going to talk more about this right after the break, and Richard's going to talk about his argument concerning the impeachment judgment clause and how President Trump does enjoy immunity for any sort of criminal acts he's been charged with while he was president, but charged with after he's left office. So stick around, you guys. We're here in the Legal Lounge, CRN Digital Talk Radio, crntalk.com. Stay with us.
When you really want Italian food, you have got to get to Columbo's. Columbo's Italian Steakhouse and Jazz Club, Colorado Boulevard, Eagle Rock. It's that little neighborhood place you wish was down the street from you. Today, it seems so hard to enjoy just a little bit of easy. So much of life seems to get in the way. But fear not, seekers of fabulous food and fun and thrill. Columbo's is Southern California's answer to Easy Street. Great grub with some of the finest steaks, the freshest fish awaiting for you to devour. Did I mention Columbo's family Italian recipes? Columbo's spaghetti bolognese, their chicken pesto ravioli, magnifico, and of course, the world's greatest meatballs. I can go on. But why go on when you can go on over to Columbo's and experience delicious and easy for yourself? Columbo's, of course, that little neighborhood place you wish was down the street from you. Columbo's, mangia bene.
Hey, want to feel young again? Are you tired, run down, have aches and pains, brain fog? This is science-based, not hype or fancy marketing. It really works. Carbon 60 helps detoxify your body on the cellular level. It stabilizes free radicals, just like the antioxidants found in red wine and berries do, but on a far smaller, more bioavailable nanoscale. It's like a bottle of electrons, helping your body to function better. You can also apply it on your skin topically, over muscles, joints, or organs. Most people feel results within minutes. This is not a drug. It's organic carbon. Feel better today. About 95% of our users report more energy and clarity of mind within 10 days. Give us a call at Greska's Carbon 60 at 720-600-6040 or visit our site at c-60.com. Call 720-600-6040 and feel young again.
The old way of living with diabetes is a pain. You've got to remember to do your testing and always need to stick your fingers to test your blood sugar. The new way to live your life with diabetes is with a continuous glucose monitor. Apply a discrete sensor on your body, and it continuously monitors your glucose levels, helping you spend more time in range and freeing you from painful finger sticks. If you are living with type 1 or type 2 diabetes and you use insulin or have had hypoglycemic events, you might be eligible for a CGM through your insurance benefits. U.S. Med partners with over 500 private insurance companies and Medicare. We offer free shipping, 90-day supplies, and we bill your insurance. Call us today for a free benefits check.
800-989-1361. 800-989-1361. 800-989-1361. That's 800-989-1361.
Trying to sell your old car? Instead, donate your vehicle to Heritage for the Blind. Pickup is free and your donation is tax deductible. Just call 1-800-785-9618. Heritage for the Blind accepts cars, vans, trucks, and boats, whether they run or not. Call right now and receive a free gift. Call 1-800-785-9618. Donate your car today. That's 1-800-785-9618.
Hi, everybody. This is Michael Horn from What's Cooking Today. Join me Monday through Friday at 8 a.m. Pacific Time, 11 a.m. Eastern Time, for the great information we give you with food, wine, travel, health, wealth, and entertainment. We call the program What's Cooking Today, and it's really a one-hour show you need to know all about things that'll be important for you for that day in your life. So if you like food, wine, travel, health, wealth, and entertainment, tune in to me, Michael Horn, What's Cooking Today on CRN.
And we are back in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com. Richard, real fast before we get back into our discussion about presidential immunity and the impeachment judgment clause, just real fast, a little history here. On this very day, Richard, 223 years ago, yeah, that's right, 223 years ago, in 1801, after 6 days and 36 rounds of voting, the House of Representatives handed the disputed election of 1800 to our friend of the show, our boy, Thomas Jefferson.
Is that right?
After ousting incumbent President John Adams. So there you go.
And can you tell us the nature of the dispute? What were they disputing? The electors?
I don't know. Maybe I don't think they liked John Adams's waistcoat or whatever it was. So we'll talk about that another day.
Right,
okay, let's talk about the impeachment judgment clause.
Right. Okay. Again, this is part of my letter that I sent to the Daily Journal. I'll just say that flat out. Arguing that Trump is immune from prosecution if we look at the Constitution. And I'm looking at the impeachment judgment clause, which is Article 1, Section 7, those of you out there who are into the Constitution. And it states in pertinent part that judgment in cases of impeachment shall not extend further than to removal from office. Now, that precatory sentence right there is interesting because it is basically saying that when it comes to impeachment, we're not going to go any further than simply removing the president from office. And there are other conditions to that, other people. He can't have any other federal jobs and so on. However, the next part says, but the party convicted, meaning the person who was impeached, but the party convicted, underline the word convicted, shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. Now, that makes it very, very clear that before anybody can be tried, after he's been in office and after he's been impeached, it's absolutely necessary that he be convicted. That is to say that the Senate, by 2/3 majority, has found whatever maybe it's the president in this case, his conduct was so egregious that he had to be removed. In a situation like that, after he is removed, he then can stand trial and be liable for trial, judgment, and punishment according to law. However, if, as like in Trump's situation where he was impeached twice, convicted 0 times, it's clear from that Article 1, Section 7, that he cannot be prosecuted now for those same conduct.
So when I read this and I first heard, your points, and it's very well written, I was like, I don't know, Richard. I mean, come on, isn't impeachment, necessarily like an administrative function?
Yes.
I mean, it's just, get the guy out of here. We don't like this guy.
Right.
And, this way, it's totally different than criminal prosecution.
Correct.
But then when I gave that some broader thought, and we've talked about impeachment a lot on this show.
Yes.
There's a reason that the framers put impeachment in the Constitution, and there's also a reason why there is case law supporting the fact that the president, while he is in office, enjoys sovereign immunity.
Correct.
And so I think we've established the fact that the only recourse criminally for a sitting president, is impeachment. So It's not an administrative function. It's not a political function, especially once it gets to the Senate.
Yes, but the whole point, too, is this. The impeachment requires an act by the House of Representatives, the majority of the number, which is half the country, if you will, their representatives, and 2/3 of the Senate, whatever that number might be at the time. Mm-hmm. So it does not permit one district attorney, one attorney general from any particular state or even several states to go after the president while he's being president, because his opponents, while he's in office, could gnaw him to death and prevent his actually conducting affairs or exercising discretion. It was intentionally done to require the intention of the whole country of what the president has allegedly done, that we need a majority in the House to at least charge him with something, and then we need a 2/3 majority in the Senate to remove him. So my point is, it's the whole country that is against the president, not just a simple DA or attorney general, as in these cases now against Trump.
Okay, so I want to read this impeachment judgment clause, and I want to interpret it, and I'd like your feedback on my interpretation.
Yes.
Okay, impeachment judgment clause, Article 1, Section 7. Judgment in case of impeachment shall not extend further than removal from office. Okay, so that part. When I read that, it says, okay, so if the House of Representatives impeaches a president and the Senate convicts him, he's kicked out of office, and when it says shall not extend further the removal from office, that means that they can't take him outside and shoot him.
That's correct.
That's what I get from it. Okay, the next part. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So that means that if you do something terrible when you're president, something criminal, a high crime or misdemeanor, you are impeached, you are convicted, you can be tried for that.
That's right.
So the rules of construction say that if he was impeached and not convicted, that party shall nevertheless not be liable and subject to indictment, trial, and judgment. That's your argument?
Absolutely. And of course, what the left is doing more and more is they're ignoring the actual words of the Constitution, and they're saying, well, okay, if he can be prosecuted after he's been convicted, along with his impeachment, then nothing says that he can't also be prosecuted if he is not convicted. So, in other words, they're saying the fact that it doesn't cover that situation is a problem. And I'm saying no, because after doing some research, there's a thing, it's a Latin expression. I know you like these, Mike.
Love them.
Expressio unius est exclusio alterius.
Oh, very nice.
This is a Latin phrase which means where a constitution or statute specifies certain things, the designation of such things exclude all others. So if they're saying that in order to be prosecuted, one must be convicted, that necessarily says that is the only condition under which he can be prosecuted. And again, it's consistent with the oath that every judge and attorney takes, and that is to ferret out the intent of those people, the legislature, that wrote the law, whether it be a constitution, statute, or a proposition. If you start adding words, which is what this D.C. Court of Appeals did, they simply added the word from.
Yeah, and it completely changes the meaning. Stick around, Richard. We'll be right back right after the break. Stay with us.
Yes.
Hi, Fred Dreyer here to talk about all natural ingredient Balance 7. Do you suffer from heartburn? Can't eat the foods you like? Then you need Balance 7. Balance 7 improves the acid-alkaline balance in the body. The right pH balance helps increase my energy, improves my memory, and gives me a great night's sleep. Unlike your immune system with Balance 7, get better hydration and nourishment during times of stress, too. Balance 7 works. I know because I use it every day. And now you can get Balance 7 and get 15% off your order. Call 800-793-9039 and mention my name, Fred. 3 1-ounce sips a day is all you need. In 3 days' time, you will feel the difference. Try Balance 7. 800-793-9039, code word Fred. You have nothing to lose with our money-back guarantee. 800-793-9039, code word Fred, or go to balance7.com.
When you really want Italian food, you have got to get to Columbo's. Columbo's Italian Steakhouse and Jazz Club, Colorado Boulevard, Eagle Rock. It's that little neighborhood place you wish was down the street from you. Today, it seems so hard to enjoy just a little bit of easy. So much of life seems to get in the way. But fear not, seekers of fabulous food and fun and thrill. Columbo's is Southern California's answer to Easy Street. Great grub with some of the finest steaks, the freshest fish awaiting for you to devour. Did I mention Columbo's family Italian recipes? Columbo's spaghetti bolognese, their chicken pesto ravioli, magnifico, and of course, the world's greatest meatballs. I can go on. But why go on when you can go on over to Columbo's and experience delicious and easy for yourself? Columbo's, of course, that little neighborhood place you wish was down the street from you. Columbo's, mangia bene.
And we are back at the Legal Lounge. Once again, thank you so much for joining us. Past and previous sessions are available on YouTube or on Rumble. Find Sierra Digital Talk Radio on both those platforms. And Richard, I rudely cut you off, but you were describing how the fact that when judges insert their own language into a statute or a constitutional privilege, what's the word I'm looking for? Provision, thank you very much. They are changing the law. Please continue, sir.
Yes, well, as I said, that this is a Latin phrase which means that where a constitution or statute specifies certain things, the designation of such things excludes all others. So they're saying here that in order to be prosecuted after a president leaves office, if he was impeached, he had to have been convicted. Now, there are those who argue that, well, that doesn't exclude his being impeached and acquitted. Well, who says that he still can't be prosecuted? Well, this thing that I just read, this is actually a case, and it's also what they call rules of construction, that is much like grammar, that unless you have rules of grammar, the writer of the document and the reader will never communicate properly because they have to go by the same rules. And there are principles of constitutional interpretation, one of which is to ascertain the intent of those who enacted it. So to determine that intent, we look first to the language of the constitutional text, giving the words their ordinary meaning. If the language is clear, there is no need for construction. If the language is ambiguous, however, we consider extrinsic evidence. Now, what that's basically saying is this. If the law that we're looking at, in this case, Article 1, Section 7, says what it says, and it's very clear, using the regular words, not in their ordinary words, no special meanings, it's clear that the only time a president can be prosecuted after he leaves office is if he's been removed by impeachment and therefore convicted. It's clear that that's what it says. one cannot be adding things to it, because to the extent that you add words to that, you are changing what the original drafters of the, in this case, Article 1, Section 7, intended. So you are in violation of one of the basic rules of construction. It's a no-no, and it should not or cannot be done, and the D.C. Circuit knows better.
Mr. Chemerinsky, of course, disagrees. And he says, quote, nothing in the Constitution makes impeachment and removal the sole way to hold the president accountable. In fact, the political realities make it highly unlikely that there ever be 2/3 of the Senate to remove a president from office. Okay, so that last part is a political consideration.
Yes, and again, he's saying, well, you know what? The Constitution doesn't fit our situation here. So we're just, it would never happen in reality. So we're just going to ignore the Constitution. That's what they've been doing for years now.
And he cites, in his argument, he cites two cases that have nothing to do with the present situation at hand.
Exactly.
He cites Nixon versus Fitzgerald, which has to do with civil cases, with civil judgments. He cites Jones versus Clinton, also a civil case, and also taking place before Mr. Clinton was president.
Correct.
And he then also goes on and says that the court, an opinion by Chief Judge, and this is Trump v. Vance, which has to do with a subpoena only.
Yes.
He talks about the court, in an opinion by Chief Justice Roberts, rejected the argument the Constitution provides a sitting president with total immunity from criminal investigations. That's not what happened, Erwin. That's not what the court ruled. The court ruled that Article 2 and the Supremacy Clause of the Constitution do not categorically preclude or require a heightened standard for the issue of state criminal subpoena to a sitting president. This has nothing to do with a state subpoena.
That is dynamite, Mike. I'm telling you, you're getting sharper by the week.
Well, what bothers me, Richard, I mean, I don't know, Mr. Chemerinsky, he could be quite nice. He oftentimes makes very spurious arguments regarding, especially when it concerns to Trump, because he's so fiercely anti-Trump.
Yes.
Look, Richard, I'm not a fan of President Trump either. But also what I am is I respect the United States Constitution and what our founders envisioned.
Yes. And I will... Now that you said that, you got me all mollixed up here, Mike. In the Clinton versus Jones case, they held that the president does not have immunity for acts that he committed prior to being president, that's for sure. But it also says, the court said that absolute immunity exists to protect the exercise of discretion while in office and does not include acts taken before becoming president. I submit that the present court, Supreme Court, if they look at that case that they held back in, it would have been 1989, I believe, they simply follow that, as they say, stare decisis, or as a precedent. They will recognize then again that we cannot have a president. He can't function if every time he decides to do something, he looks over his shoulder, wait a minute, if I do this and I leave office, am I going to get nailed for doing something wrong by my opponent for sure? So this is why the Founding Fathers were prescient in making sure that under Article 1, Section 7, when we're talking about impeachment, we're talking about conviction before he can be prosecuted after he is impeached. And in both instances, for Mr. Trump, he was prosecuted, impeached, but he was acquitted in both instances, and therefore he cannot be prosecuted for that conduct now.
Very well said. And this is not a double jeopardy argument. This is a strict reading of the impeachment judgments clause. And we'll talk more right after the break about impeachment. We're going to talk about the impeachment of one Mr. Mayorkas. Stick around.
Savor the past and savor the glory days of Las Vegas. Enjoy 70 years of true Las Vegas history as 4 generations of family wait to greet you at the legendary Bootlegger Italian Bistro. Wine, dine, and experience Mama Maria's award-winning original recipes while surrounded by original family photos and celebrity memorabilia. Enjoy piano artistry nightly with music from the Great American Songbook in our main formal dining room. The Bootlegger Italian Bistro, open 24/7, 7700 Las Vegas Boulevard South. In the entertainment capital of the world, the Bootlegger Italian Bistro, open 24 hours a day, 7 days a week. 7700 Las Vegas Boulevard South, in the entertainment capital of the world. It's Vegas, baby.
The Kaanapali Beach Resort Association is reopening and is welcoming guests. While some properties are opening sooner than others, all properties are taking reservations, and we look forward to your return. Go to kaanapaliresort.com for all the latest and up-to-date information on what's happening at Kaanapali Beach. That's Kaanapali Beach on the west side of Maui. There's so much to do. With a short drive from Maui Airport, we're on the tropical side of Maui and offer breathtaking scenery, an incredible array of delectable dining, and activity choices to meet your needs. We invite you to visit Kaanapali Beach Resort, but please be sensitive to the devastation that our beloved West Side community has suffered. Lahaina is closed and will be for some time. Come to our open areas and support us as we adapt to a new way of life without our beloved Lahaina. Come visit the west side of Maui, Kaanapali Beach. Visit us online at kaanapaliresort.com. That's KAANAPALI resort.com.
Attention real estate investors. Do you need cash immediately? If you own one or multiple rental properties, you can use your equity to get cash out fast. The best part is we don't need tax returns or even a good credit score. At America's Loan Source, we are not a bank and we don't have bank rules. We make the decisions to loan you money, and there's no limit how much we can give you. Some clients have gotten as much as $500,000 or more within days. Use the money any way you want. If you own one rental property or 100 and COVID has left you in a cash crunch, we can help you turn your equity into fast cash. Call now for details and close in as little as 10 days and get the cash you need. 800-353-1760. 800-353-1760. 800-353-1760. That's 800-353-1760.
And we are back in the Legal Lounge, and I want to extend to Mr. Chemerinsky. Anytime he wants to come on the show, we would be happy to have him to have a nice, a very civil debate about some of these issues. We very much enjoy that. In fact, I would even buy Mr. Chemerinsky or present him with a nice bottle of wine if he ever came.
Absolutely, even some chocolate if he likes.
Exactly, whatever he likes. Name your pleasure, name your poison, Mr. Chemerinsky. We'd love to have you come on, and no malice towards the man. I mean, this is what we talked about this before, Richard. We like this kind of stuff. The thing is that what bothers me about Chemerinsky is he speaks so authoritatively about it.
Yes.
Where rather than actually making an argument and letting the argument itself stand.
Yes.
And he said something interesting about the D.C. circuit, about how it's emphatically ruled. What was the language?
Well, he says, indeed, the D.C. circuit, in its unanimous decision, emphatically ruled against Trump. And he goes on to say that the court declared, now get this, we cannot accept that the office of the presidency places its former occupants above the law for all time thereafter. And I'm saying, sir, please read the Constitution, specifically Article 1, Section 7. That's what the Supreme Court is bound to apply as written. What you and others are trying to do, Mr. Chemerinsky, is to amend it without going through the proper amendment process, which is Article 5 of the Constitution.
All right, Richard, we're going to be following this moving forward. All right, to wrap things up, we're running short on time. Let's talk about another impeachment. We're going to talk about the impeachment of Alejandro Mayorkas. And
yes.
Full disclosure, Mr. Mayorkas' brother, I've never met Mr. Alejandro, but I've met his brother, James. He's a very nice man. He does my family's taxes. He was impeached, and I'm of two different minds here, Richard. I think I'm more aligned with Mr. McClintock's argument here. Mr. McClintock, of course, a representative from here in California, he voted no to impeach because he was pretty much like, look, what Mayorkas is doing is policy by the Biden administration. You can't impeach a guy for doing what his boss told him to do.
Well, see, I disagree with that, Mike.
Please.
Because again, you have to do what is right, though.
Mm-hmm.
You can't simply do what someone tells you if you know it's wrong. And what sticks in my throat here is this: Mr. Mayorkas was on the south border.
Yeah.
He came back here and he was asked questions whether or not the border is closed, and he said yes. Now he knows better. Now, I know that some people, whoever was in charge, did clean the matter up so it looked like they do for the homeless people. They put them in shelter.
They whitewashed it.
Right.
Yeah.
But he knows better. He watches Fox like everybody else on occasion. He's seen films. He knows the border is open. So for him to lie, I don't care who told him that. I think that is an impeachable.
You really? I mean,
Yeah.
I would be 100% behind a censure for that. But does lying to? Well, I guess is it illegal to lie to Congress? I think it is.
Well, I mean, how else are we going to treat these people who lie and have the ignorant among us rely on their lies? Something has to be done. And again, we're going back to what the Constitution says. Does it say high crimes and misdemeanors? Now, whether this is one of those situations, I believe it is. And I believe next on the agenda is the impeachment of Mr. Biden and the vice president. And once those two are out of the way, hopefully it'll be soon, Mr. Johnson, the Speaker of the House, will become the President of the United States and will immediately shut the border down. Then we'll find out for sure whether the border was actually open or closed.
There you have it, folks. Richard, thank you very much. That was a good one today.
Very good.
All right. Thank you so much. Once again, make sure to check out Richard's fantastic book, America, An Illusion of Freedom. It's available on Amazon.com, Barnes & Noble, and on iTunes. You can also check out all past and previous sessions of this high-quality broadcast. They're available on Rumble and on YouTube. Search CRN Digital Talk on both those platforms, as well as a podcast on crntalk.com/podcaster. We will see you guys next week here in the Legal Lounge on CRN Digital Talk Radio, crntalk.com.